And the lawyer Kwame Afenyo Markin, the minority leader in parliament, wabe clash with Tamale High Court judges and the NDC caucus in parliament. Efa Pandai seat ya say Tamale High Court nullify seat no. Afenyo Markin, in fact, ne niabre pa wabe blasti womu. Memo nchiri mu no akire wadwen amame. Ewo comment section. Ahi Penyah Block Media. Mess was say need you. Obe like video no that my subscribe button, number click notification icon for latest updates. Now be chire wadwen da amame. Ewo comment section. Meza so baso no achego so enya bi ahwe. Enti akwa 24 election mu no. Pandai seat, Pandai parliamentary candidate. Ho no eye MPP ni e na rene akonwa no. In peace. I say watina akonwa no so January, February, March, April, May, June, July, August, September, October, November. Yanka Bisham out of nowhere recently about a week ago. Adabai said Tamale High Court. I got that election results because according to the NDC piece, Trim said the election party well who see it was the Assembly Echo Court. Emma Tamale High Court judges from Mutina Assembly soon. Almost there be said there I didn't see ya ya nullify seat no. Ya nullify seat no. It is the seat now a vacant seat. It will mean say yen san koya re-election. Election re-run. E wo ho no mo. Just yes another by-election. Pandai parliamentary candidate. Ya nullify the seat. E wo parliament. Ama adu e ba ye no. NDC side in parliament. That's na omo dey be hunhuna Ghana for ne MPP for no. E say why you say over try over challenge, the outcome or the judgment from the Tamale High Court no. They will file contempt against you. Just you are trying to disrespect the court. You are trying to, belittle the court. And by doing so, no, they will file a contempt against you. Now, I know, I'm a lawyer coming out for your marking. I am a minority leader in parliament. The mighty minority leader. The mighty minority leader in parliament. We best stand on his feet. Now, in fact, we are blasting Tamale High Court judges, and the NDC caucus in parliament. We are blasting
Let me state this emphatically and without equivocation. The minority will lawfully resist any attempt, whether subtle or brazen, to bar him from representing his people. We will not permit democratic legitimacy to be overturned by judicial improvisation. The factual background. In December 2024, Honorable Markin blàst was duly declared Member of Parliament for the Pandai constituency following a peaceful and orderly election. His opponent subsequently filed a petition challenging alleged irregularities in 41 polling stations and aspects of the collation process. The relief sought by the petitioner himself was clear and specific. He requested rerun in those 41 polling stations. And by the way, he had, prior to the gazetting of the results, filed a petition. And when counsel for Mr. Honorable blàst raised a preliminary objection, and same had been argued, and the very day the judge was to determine the matter, they quickly filed a notice of withdrawal, which was quite strange. This judge, who knows that when matters close, and he's fixed a date for judgment, no matter what, he's supposed to deliver a judgment, decided to stay away from determining the matter because a party has decided belatedly to file a notice of withdrawal of the case. Yet, in a development that defies ordinary legal reasoning, the High Court issued an order directing a full rerun of the entire Pandai parliamentary election, covering all 152 polling stations, to be completed within 30 days. As if this judge is not aware of the Supreme Court decision in the Akufo-Addo and others versus John Dramani Mahama and others in the 2012 presidential petition. The sad part of it is that the NDC candidates and his supporters were aware of the judgment before the day, to the extent that on the day of the said judgment, the regional minister led a team of NDC party faithfuls into the courtroom anticipating the expected results. The result that they were going to have judgment in their favor. The judge, who spent minutes, walked out of the courtroom claiming that his judgment will be ready on Friday. Meanwhile, in less than 24 hours, a court order was being served on Parliament and Honorable Nyindam. What kind of kangaroo judicial system we have it now in Ghana? The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of court. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never an acceptable approach when the stakes are this high, when a parliamentary seat hangs in the balance, when constitutional rights are imperiled, and when the votes of thousands of citizens face annulment. For a judge to casually void an entire constituency elections without first ensuring that a complete reasoned judgment was prepared and published is not merely irregular, it is judicial irresponsibility of the highest order. We have carefully reviewed the relevant authorities, including the Supreme Court's decision in Kojoba and Ghana Water Company Limited and another. In that landmark case, the court affirmed a long-standing principle, quote, in the interest of substantial justice, a court may, in limited and carefully circumscribed circumstances, grant relief not specifically sought by a party, but only where such a relief is unmistakably supported by the pleadings and evidence, causes no unfairness or surprise, and brings true finality to the issues properly before the court. Let me emphasize, this is a narrow exception, not a judicial blank check. The Supreme Court made abundantly clear that such power is to be exercised only when, one, the parties have had a full and fair opportunity to address relevant issues, the evidence unequivocally supports the alternative relief, and three, there is no element of surprise, prejudice, or procedural ambush. Now, ladies and gentlemen, none, absolutely none, of those conditions exist in this case. The High Court order is not a principled application of the Kojoba doctrine or any other known doctrine. It is a brazen abuse of it, like the judge who invoked the animal farm to remand Abronye. Consider the following facts. One, the petition did not plead irregularities in all 152 polling stations. The petitioner did not lead evidence concerning 152 polling stations. The parties never argued about 152 polling stations. And no one, neither the respondent, nor the Electoral Commission, nor the voters of Pandai, was put on notice that the entire constituency election was at risk of annihilation. In fact, the key witness to the petitioner underscored the fact that all they needed was a rerun in some 41 polling stations. He again added that the collation was done without due notice to him. Has the judge read the CI? Has the judge listened to the Electoral Commission regarding the violent conduct of the petitioner and his followers, leading to the termination of the collation at Pandai and eventual transfer of collation to Tamale? Indeed, this is not substantial justice. This is substantial injustice, a textbook case of judicial overreach masquerading as equity. Let me be clear. We do not accept that the petitioner proved his case. But even if he did, the court found credible evidence of wrongdoing. The remedy imposed is still fundamentally flawed. It is whimsical, unlawful, and manifestly unconstitutional. Under Section 20 of PNDC Law 284, the High Court may void an election only to the extent that proving non-compliance affected the results. The law demands precision, not wholesale distraction. And my Lord Atuguba was very clear in the case of Akufo-Addo and others, where pink sheets were not signed. I remember the argument of Leonard Tachutikata in that matter, where he said it would be constitutionally unwise to nullify the vote merely because the presiding officer did not sign. Has the principle changed? Or now we have a principle of convenience? The law demands precision, not wholesale distraction. It requires, 1, clear identification of the specific irregularities, rigorous evaluation of their impact on the outcome, and finally, a tailored remedy, surgical, proportionate, and fair. What we have witnessed instead is not surgical intervention. It is judicial carpet bombing. Rather than addressing the 41 challenge polling stations with the scalpel the law requires, the learned judge deployed a sledgehammer and demolished the entire constituency. This is not law. This is judicial carelessness dressed up as electoral justice, similar to what that circuit court judge did in the Abronya case. Here is a number that should echo across the nation. The 111 polling stations. There's an assault on Article 42 and the sovereignty of the innocent voters. In 111 polling stations, more than 2/3 of the constituency, there was no allegation and no evidence of any irregularities whatsoever. None. Yet the lawful vote of thousands of innocent citizens in those stations have been discarded like waste paper, swept away by judicial order that never bothered to distinguish the guilty from the guiltless, if they at all existed. For the avoidance of doubt, Article 42 of the Constitution guarantees every Ghanaian the sacred right to vote. That right is not a privilege. It is not discretionary. It is fundamental. Yet the High Court has violated that right in 101 polling stations without justification, without evidence, and most troublingly, without apparent consent. You do not defend democracy by disenfranchising the innocent. You do not cure irregularities in 41 polling stations, by burying the valid vote of thousands who committed no wrong. This order is not merely disproportionate. It is an assault on the sovereignty of the people of Pandai. Beyond the immediate injustices injustice lies a deeply alarming precedent. By this reckless order, my Lord Bart Planbrew has sent an unmistakable message to every political mischief maker and electoral saboteur in Ghana. Create confusion in few polling stations, destroy materials, disrupt collation, trigger controversy, and you may be rewarded with a full rerun. This is not justice. This is a recipe for electoral anarchy. The judge has unwittingly weaponized disruption. He has created a perverse incentive structure where chaos becomes strategy, where sabotage becomes litigation, and where losing at the polls can still mean winning in court, not through superior evidence, but through superior disorder. This is not how a serious democracy functions. This is how democracies unravel. Let the nation hear the minority caucus clearly and unequivocally. One, and for the avoidance of doubt and at the risk of being repetitive, Honorable Matthew Nyindam remains the Member of Parliament for Pandai, and this is non-negotiable. He will continue to sit in Parliament to vote, to debate, and to represent his people with full authority. No premature exclusion will be tolerated. We will lawfully and vigorously resist any attempt to remove him before appellate process is properly concluded. We fully support his appeal and his application for stay of execution. The law must run its course, and it must run fairly. Whilst Article 99 makes the Court of Appeal the final arbiter in parliamentary election petition, where a high court decision is so flagrantly unconstitutional, the minority will not hesitate to support further constitutional litigation before the Supreme Court. When a ruling assaults the Constitution itself, no judge is above scrutiny, and no decision is beyond correction. The Constitution is supreme, and when a ruling violates it, judicial deference yields to constitutional duty. To the good, peaceful, and hard-working people of Pandai, again I speak to you directly. Your votes matter, your voice matter, your MP remains at post. Do not be discouraged. Do not be shaken. Do not allow this temporary turbulence to diminish your faith in the democratic process you honored with such commitment. You stood in long queues under the sun. You voted peacefully and purposefully. You respected the process from beginning to end. Your loyalty to the Republic will not be betrayed by one reckless judicial act. The law will vindicate the truth, and the truth will vindicate your voice. Justice may sometimes be delayed, but it cannot ultimately be denied. We stand with you, people of Pandai. We will fight with you, and we will prevail. Although we go through difficult moments, we know the better days of our nation are ahead of us. And to conclude, this judgment is not merely flawed, it is dangerous. It does not advance justice, it obstructs it. It does not uphold constitutionalism, it undermines it. It does not protect the people, it punishes them without cause. His Lordship Justice Bart Planbrew may be a learned jurist, and we respect the office he holds. But respect for judicial office does not require silence in the face of judicial error. Quite the contrary, it demands that we speak, that we challenge, that we insist on fidelity to the Constitution and the rule of law. And so we say this with the utmost clarity. As long as the minority caucus stands, this judicial misadventure will not pass quietly into legitimacy. We will, challenge it through every lawful avenue available. We will expose its flaws with rigorous legal arguments, and we will defeat it. Not through force. I repeat, not through force, because we have none. Not through intimidation, because we have none. But by law, by constitution, and by truth, we will appeal to the conscience of judges who would want to uphold their judicial oath and be guided by their conscience and their love for country. The soul of our democracy depends on getting this right. The integrity of our electoral system demands it, and the people of Pandai deserve nothing less. We thank you so much indeed.
Kyerɛ wadwe ma me ɛwɔ comment section. Hi Penyah Block Media. Accra.